Hello students, welcome to Ashish Polala classes. Today in the present lecture of CPC, I am going to discuss with you section number 16 of CPC. In the last video, we had started the provision in relation to the place of suing, in which we had made detailed study of section number 15 of CPC, which says that every suit shall be instituted in the court of lowest grade competent to try it. Okay. But today in the present video, I am going to discuss with you the provision of section number 16. Section number 16 is also famous in respect of suits of immovable property, which governs the provisions in relation to the institution of suit in respect of immovable property. Section number 16 starts with a heading in which it says that suits to be instituted where the subject matter situate. That subject matter may be the immovable property or it may be the movable property which is actually under distraint or attachment. In the starting of section number 16, it has been made clarified that section number 16 is to be read subject to any pecuniary or other limitation which may be prescribed by any special law. Okay, that means to say if any type of pecuniary or other limitation may be prescribed by any special law, that has to be complied with, and after complying with that pecuniary or other limitations of that particular law, suits for the recovery of immovable property, in which you sought the recovery of immovable property from defendant, and that recovery of immovable property may be with or without rent, or it may be with or without profits. So suits for the recovery of immovable property with or without rent or profits has to be instituted before the court within whose territorial jurisdiction that immovable property is situated. Okay. And number two, if you want to get your share separated from the unpartitioned portion of immovable property, if you want to file a suit for the partition of immovable property, then for institution of that partition suit, you have to present your plaint before the court within whose territorial jurisdiction that immovable property is situated. If you are going to file any suit for the foreclosure of mortgage, if you are going to file any suit for the sale of mortgaged property or redemption of any mortgaged property, then for foreclosure, sale or redemption in the case of a mortgage or charge upon immovable property, you have to file your civil suit before the court within whose territorial jurisdiction that immovable property is situated. If there is a dispute between two persons and for resolving that dispute, they want a determination of any right to immovable property, or they want to determine any interest in immovable property from the court, then they have to file a civil suit for the determination of any right to or interest in immovable property before a court within whose territorial jurisdiction that immovable property is situated. If a person has committed any wrong, or we can say that if a person has committed any tort of nuisance, trespass, or infringement of any other right of immovable property, and the aggrieved person wants to get the compensation for the wrong to immovable property. So for compensation for wrong to immovable property, the civil suit has to be filed before the court within whose territorial jurisdiction that immovable property is situated. Clause number F of section number 16 is very important because this clause is related with the movable property, not with immovable property. If you want to recover any movable property, but that movable property is actually under distraint or attachment of any authority, then that movable property takes the shape of immovable property. And for the recovery of movable property, which is actually under distraint or which is actually under attachment, the civil suit has to be instituted before the court in which that movable property is actually under distraint or attachment. So means to say that all the civil suits which has been given in clause number A to F, all these type of suits shall be instituted in the court within the local limit of whose jurisdiction the property, in case it is the immovable property or movable property which is actually under distraint or attachment, is situate. But there is also a proviso. We can say that there is also an exception in respect of a case in which the suit can be filed within the local limit of the jurisdiction where the property is situated or within the local limit of which the defendant actually and voluntarily reside or carry on business or personally work for him. And what is that proviso? Let us study. This proviso is applicable in respect of a suit in which you want to get any relief respecting the immovable property. If you want to get any type of relief in respect of any immovable property, or if you want to get any compensation for wrong to immovable property, and if that immovable property is held by defendant or on behalf of the defendant, and where the suit or where the relief can be entirely obtained through the personal obedience of the defendant. I want to repeat, where a suit is in respect of relief respecting immovable property, or where a suit to obtain the relief respecting compensation for wrong to immovable property. And if the immovable property is held by or on behalf of the defendant, then that type of civil suit may, where the relief sought can be entirely obtained through his personal obedience, be instituted either in the court within the local limits of whose jurisdiction that immovable property is situated, or either in the court within the local limits of whose jurisdiction the defendant actually and voluntarily reside. First of all, where the defendant is residing, or where the defendant carries on business, or where the defendant personally works for him. So this proviso gives the choice to the plaintiff that he may file the suit where the property is situated or where the defendant is residing or carries on business or personally work for him. At the end of section number 16, there is an explanation which tells that in this section property means property situated in India. That means to say the provision of section number 16 can be applied only in respect of a property which is situated in India. This section will not be applicable in case of those properties which are situated out of India. So this is something about the bare language of section number 16. Now we will discuss section number 16 in detail, clause by clause, proviso wise and explanation wise. So let us start clause number A of section number 16, in which we have a heading that suit for the recovery of immovable property. According to clause number A of section number 16 of CPC, all suits in which you want to take the possession of immovable property, or you want to recover the immovable property, the possession of which has been lost to you. So all type of suit for taking possession or recovery of immovable property must be instituted before the court within the local limit of whose jurisdiction that immovable property is situated. But it is very important to note here, not only the territorial jurisdiction of the court is to be seen, the competence of the court is also to be seen, because the suit can be instituted only in the court who is competent to try that civil suit. So, means to say, if a court has the territorial jurisdiction, but it has not the competence to try that civil suit, the suit cannot be instituted in that court. So what is written? Let us study. However, it is very important to note here that court within the local limit of whose jurisdiction the immovable property is situated must also be competent to try that civil suit. Let us take an example to make it simple. A suit for the recovery of immovable property. The immovable property which is situated in the city of Mumbai. This suit must be filed in the city civil court of Mumbai, which is having the jurisdiction to entertain and decide the suit. Because the city civil court of Mumbai has only the jurisdiction, which is the territorial jurisdiction, as well as it has also the competence to entertain and decide the suit. The small causes courts in Mumbai has only the territorial jurisdiction, but it has no competence to try and decide such suit. So this type of suit for the recovery of immovable property cannot be filed before the small causes courts, because the small causes court in Mumbai has no jurisdiction to try and decide such suit. So this is something about clause number A, in which we had studied that suit for the recovery of immovable property must be instituted before the court within the local limit of whose jurisdiction the immovable property is situated, and that court has also the competence to try and decide that particular civil suit. Now let us study clause number B of section number 16, in which we are going to file the suit for the partition of immovable property. But where this type of civil suit is to be filed, it must be instituted before the competent civil court within the jurisdiction of which the immovable property is situated. So according to clause number B of section number 16, any suit in respect of partition of immovable property, any type of civil suit in which the partition of immovable property is sought by the plaintiff, this suit must be instituted before the competent civil court. The civil court must have the territorial as well as competence jurisdiction. Any suit in respect of partition of immovable property must be instituted before the competent civil court within the jurisdiction of which that immovable property is situated. Okay, this is more than sufficient in respect of clause number B. Now let us study clause number C of section number 16, in which we will discuss in detail what is the foreclosure suit, what is a sale suit, or what is a redemption suit of mortgage property. So clause number C of section number 16 is dealing with the suits for the foreclosure, sale, or redemption of mortgaged immovable property. What is the mortgage? I will tell you that is also. If any immovable property is mortgaged according to clause number C of section number 16, if any immovable property is mortgaged by one person in favor of another person, and thereafter, due to any dispute, any type of civil suit for the foreclosure, sale, or redemption is required to be instituted either by them in respect of that immovable property which is mortgaged, then that civil suits is to be instituted before the competent civil court within the jurisdiction of which the immovable property is situated. So let us repeat, if any immovable property is mortgaged, then if any type of civil suits for the foreclosure, sale, or redemption is required to be instituted in respect of that immovable property, then that civil suits is to be instituted before the competent civil court within the jurisdiction of which the immovable property is situated. Let us take an example to make it simple. A mortgages his immovable property to B. Why he has mortgages his immovable property to B? To secure the payment of money lent to him by B. As a security purpose, he mortgaged his immovable property in favor of B. So in this case, A is the mortgager and B is the mortgagee. Okay. Now, A has to repay the amount on or before the due date to B. Now, if A does not repay the loan to B to him on the due date, then what B can do? Then B may institute a civil suit against A for the sale of mortgaged property. He will pray to the court that mortgaged property should be sold, and out of the sale proceeds of that mortgaged property, my mortgage debt may be paid to me. Okay. So if we want to file the civil suit for the sale of the mortgaged property, then it has to be filed before the court within whose territorial jurisdiction that mortgaged immovable property is situated. Or if A does not repay the loan of B, then what B can do? Moreover, B may also sue A for the foreclosure of the mortgaged property. What is the foreclosure of the mortgaged property? In the suit of foreclosure of the mortgaged property, if the court is satisfied in respect of the mortgage, then the court can pass a decree in a foreclosure suit, which will provide that if the mortgager fails to pay the amount that may be found to the mortgagee within a time specified by the court. Normally, this time may be the 6 months time. First of all, the court will say that it is corrected, that mortgage has been created. Now, the court will give the time to the mortgager to repay the amount to the mortgagee. It will specify the time within which the payment has to be made by the mortgager to the mortgagee. But if the mortgager fails to pay the amount within a time specified by the court, then mortgager shall be absolutely debarred of all the rights to redeem the property. That means to say, he cannot get back his property thereafter if he do not repay the amount to the mortgagee. The mortgagee will become the complete owner of that particular property. On the other hand, what will happen if A offers payment of the mortgage debt to B, but B, with the malified intention, disputes the amount with A and also refuses to reconvey the property to A. A is ready to pay the amount, but B is not accepting that amount, and he also making the refusal that he will not reconvey the property to A. Then what A can do? Then A may sue B for the redemption of the mortgage, that I am ready to pay. Let us take the amount from me and reconvey the property to me. then A may sue B for the redemption of the mortgage. And in that suit, what will happen? The court will passes a decree in which court will order an account in relation to the amount, that what amount is due to B by A. And court will give the direction that upon A paying to B the amount so due, B shall reconvey the property to A. So if in the future A will pay the amount to B, B has to reconvey the property to A. If he will not do, then A can get the execution from the court, and then the court will reconvey the property to A according to the provisions of order number 21 of CPC. So all types of suits for the sale of mortgage property, for the foreclosure of the mortgage property, or for the redemption of the mortgage property, all these type of suits must be instituted before the court within whose territorial jurisdiction the mortgaged property is situated. Now let us discuss clause number D of section number 16, in which if the determination of any other right to or any determination of any interest in immovable property is involved, then a suit for the determination of any other right or interest in immovable property can be filed before the court within whose territorial jurisdiction that immovable property is situated. Means to say, a suit for the determination of any other right which has not been covered in clause number A, B, and C. A suit for the determination of any other right to, or a suit for the determination of any interest in immovable property is triable only by that court within whose territorial jurisdiction the suit property, which is the immovable property, is situated. No other court within whose territorial jurisdiction the property is not situated. No other court is vested with the power to entertain such a suit which has been given in clause number D. It has also been made clear by me in my notes that it is very important to mention here that clause number D is related to such suits in which the determination of any other right to or interest in immovable property is not covered by clause number A, B, and C. What are those suits which are covered by clause number D? Let us study one by one. The suit which fall under this category includes: number one, a suit for injunction restraining interference with the plaintiff's possession over the land. That means to say, if a person is in the possession of any particular land and another person without any justifiable reason wants to get vocation of that person, or he interfere in the peaceful possession of the plaintiff, then a suit for permanent injunction in which plaintiff demand the injunction restraining interference with his possession over the land can be instituted before the court within whose territorial jurisdiction that immovable property is situated. A suit for maintenance with the prayer that payment should be charged on immovable property also falls within this category. A suit for specific performance of agreement to sell immovable property also falls within this category. A suit asking relief of declaration, which is related with the determination of any right to or interest in immovable property, it also falls within this category. Let us take an example. If a person has any dispute with the other persons who are in possession of the land, and he is saying that he has 1/3 share in that land, and the other person refuses that you have not any right in this particular land. If he wants to get the declaration from the court that I have the 1/3 share in the immovable property, then that type of suit can be filed by using this provision within the court, before that court within whose territorial jurisdiction the immovable property is situated. So a suit asking relief of declaration, which is related with the determination of right to or interest in immovable property, falls within this category. And fifthly, suit relating to have water course opened, right to eject a person from the land, right to future rent to fishing in enclosed water, right to easement, right to remove obstructions in the immovable property also falls within this category. So all these type of suit must be brought in the court within whose territorial jurisdiction the property is situated, but all these suits must be filed keeping in view the pecuniary jurisdiction of that particular court. Now come to clause number E of section number 16, which deals with the wrong to immovable property. This clause is applicable to all those suits in which compensation is claimed by the plaintiff. But why? For wrong done to the immovable property by the defendant. What is the meaning of wrong to immovable property? The expression wrong to immovable property denotes all kinds of torts. And what is the meaning of tort? Civil wrong. In relation to immovable property, it may be the trespass to that immovable property. It may be the nuisance to the immovable property. It may be the infringement of easement right. So this is the meaning of wrong to immovable property. If any these type of tort are committed with the immovable property and you want to get compensation in respect of these wrong to immovable property, then the appropriate forum for claiming damages for such wrong is the civil court within whose territorial jurisdiction that immovable property is situated. But again, pecuniary limitation of that particular court must be kept in mind. Okay, so this is something about clause number E of section number 16. Now come to clause number F of section number 16, which is dealing with the movable property, which is actually under distraint or which is actually under attachment. Normally, we have seen that movable property does not have locality of its own. Instead, it follows the person. Let us suppose if I have a car, where I will go, the car will go with me. If today I am residing in Kapurthala, then car with me at Kapurthala. If I will start residing in Delhi, then I will bring my car to Delhi. But if the movable property is attached by any authority, then its locality becomes fixed. So that movable property will become the immovable property. And if any person wants the recovery of that property, which is under the distraint or attachment of the authority, then suit for recovery of such a property which is under distraint or attachment must be instituted in a court within whose territorial jurisdiction the immovable property is situated. But again, it is very important to mention that before filing the civil suit before a court, pecuniary limitation of that court is to be kept in mind. So we have very successfully studied all the clauses of section number 16, but there is also a proviso to section number 16. It can be said to be the exception where the general rule which is given in clause number A to F of section 16 will not be applicable. This is a proviso which is attached to section number 16 of CPC. This proviso gives an option to the plaintiff that he can choose the court before which he wants to file a suit. What is that option? This option is given only in respect of a suit which is in respect of relief respecting immovable property, or where a suit is for compensation for wrong done to the immovable property. And when that immovable property is held by or on behalf of defendant by other person. And where the relief, it is very important to note, where the relief sought can be obtained through the personal obedience of the defendant, then plaintiff has the choice. What is that choice? Then the plaintiff may bring the suit in relation to the property in any one of the following courts. And what are those courts? The first court is that court, the court within the local limit of whose jurisdiction that immovable property is situated. Okay. Or the another court is that court within the local limit of whose jurisdiction either the defendant actually and voluntarily resides, or within the local limit of whose jurisdiction the defendant carries some business, or within the local limit of whose jurisdiction the defendant personally works for gain. So if the plaintiff files suit within or before any court which falls within these two options, then it is properly valid. Plaintiff has the choice. At the end of section number 16, there is the explanation. The explanation attached to section 16 says that the term property may be movable property or immovable property. Property only means a property which is situated in India. Therefore, by this explanation of section number 16, it has been made clear that the authority of Indian courts is limited to the suits which is relating to the properties which are situated within India. And the authority of the Indian court does not extend to those properties which are situated outside India. Hence, the Indian courts have no jurisdiction to entertain the suits in respect of the properties which are situated outside India. That means to say, Indian courts can entertain only those suits in which the property is situated in India. If the property is not situated in India or it is situated outside India, then section 16 will not make any help. Indian courts cannot entertain and try that particular suits in which the property is situated out of India. So this is something about section number 16, in which we had discussed in detail the suits in relation to immovable property or suits in relation to movable property, which is actually under distraint or attachment of any authority. So if you like my video, then subscribe my channel, and for getting the notifications of my videos, click on the bell icon. If you want to get the notes of my law lectures, then you can go to ashishpolalaclasses.blogspot.com. Thank you very much.